construed and applied to promote its underlying purposes and policies. 2. Underlying purposes and policies of this Act are: a. To simplify, clarify, and modernize the law governing commercial transactions. b. To permit the continued expansion of commercial practices through custom, usage, and agreement of the parties. c. To make uniform the law among the various jurisdictions. 3. The effect of provisions of this Act may be varied by agreement, except as otherwise provided in this Act, and except that the obligations of good faith, diligence, reasonableness, and care prescribed by this Act may not be disclaimed by agreement, but the parties may by agreement determine the standards by which the performance of such obligations is to be measured if such standards are not manifestly unreasonable. 4. The presence in certain provisions of this Act of the words "unless otherwise agreed" or words of similar import does not imply that the effect of other provisions may not be varied by agreement under subsection 3. 3-103, 4. 4. Good faith means honesty in fact and the observance of reasonable commercial standards of fair dealing. On Cornell this section reads reserved. Wow, why is it gone? 4-104, b. Good faith, see section 3-103. Notice this section is removed in its entirety out of the web version for Cornell Law 2. 5-102, a. 7. 7. Good faith means honesty in fact in the conduct or transaction concerned. 6-103, 3. Article 6 is governed by sales, bulk sales, see 6-103, 3. 7-403 and 7-404. 4. Person entitled under the document means holder in the case of a negotiable document, or the person to whom delivery is to be made by the terms of or pursuant to written instructions under a non-negotiable document. See 8-102, 7, for definition of entitlement holder. 7-404. No liability for good faith delivery pursuant to receipt or bill. A bailee who in good faith, including observance of reasonable commercial standards, has received goods and delivered or otherwise disposed of them according to the terms of the document of title or pursuant to this article is not liable therefor. This rule applies even though the person from whom he received the goods had no authority to procure the document or to dispose of the goods, and even though the person to whom he delivered the goods had no authority to receive them. 8-102, 10. 7. Entitlement holder means a person identified in the records of a securities intermediary as the person having a security entitlement against the securities intermediary. If a person acquires a security entitlement by virtue of section 8-501, b. 2, or 3, that person is the entitlement holder. 8-102, 10. Good faith for the purposes of the obligation of good faith in the performance or enforcement of contracts or duties within this article, means honesty in fact and the observance of reasonable commercial standards of fair dealing. Again, this section is reserved on Cornell's website. 9-102, 43. 43. Good faith means honesty in fact in the conduct or transaction concerned. Again, notice the section on Cornell law reads reserved. Is this getting coincidental or what? To summarize every section 1, 3, 4, 5, 8, 9 all tell you good faith as in 1-105, 2 and 6 talk about sales yet direct you back to 1-105 for good faith provisions, 7 directs you to an entitled party, which is found in Article 8, and Article 8 brings you back to 1 for the good faith clause, plus it talks about an entitled party. And Cornell hides most the good faith provisions of the UCC. Over time I have heard so much about the new Article 9 and how important it is to read it because it affects everything in commerce. First read the paragraph below and then look at the section from Article 9 itself and ask yourself how important it really is, or is not. Now, in order for Article 9 to pass any test, one should ask themselves, if Article 9 governs any interest, regardless of form, yet the party asserting any interest cannot do so without violating law, or there is evidence that that party asserting an interest really cannot assert an interest based upon their own application and registration to do business in a given state, how can Article 9 even apply to them or you or even the issue? Subpart 2. Applicability of Article 9 to 109. Scope. A. General scope of article. Except as otherwise provided in subsections C and D, this article applies to 1. A transaction, regardless of its form, that creates a security interest in personal property or fixtures by contract. 2. An agricultural lien. 3. A sale of accounts, chattel paper, payment intangibles, or promissory notes. 4. A consignment. 5. A security interest arising under Section 2-401, 2-505, 2-711, 3, or 2A 508, 5, as provided in section 9 to 110, and 6. A security interest arising under section 4 to 210 or 5 to 118. b. Security interest in secured obligation. The application of this article to a security interest in a secured obligation is not affected by the fact that the obligation is itself secured by a transaction or interest to which this article does not apply. c. Extent to which article does not apply. This article does not apply to the extent that 1. A statute, regulation, or treaty of the United States preempts this article. 2. Another statute of the state expressly governs the creation, perfection, priority, or enforcement of a security interest created by the state or a governmental unit of the state. 3. A statute of another state, a foreign country, or a governmental unit of another state or a foreign country, other than a statute generally applicable to security interests, expressly governs creation, perfection, priority, or enforcement of a security interest created by the state, country, or governmental unit, or 4. The rights of a transferee beneficiary or nominated person under a letter of credit are independent and superior under section 5 to 114. d. Inapplicability of article. This article does not apply to 1. A landlord's lien, other than an agricultural lien. 2. A lien, other than an agricultural lien, given by statute or other rule of law for services or materials, but section 9 to 333 applies with respect to priority of the lien. 3. An assignment of a claim for wages, salary, or other compensation of an employee. 4. A sale of accounts, chattel paper, payment intangibles, or promissory notes as part of a sale of the business out of which they arose. 5. An assignment of accounts, chattel paper, payment intangibles, or promissory notes which is for the purpose of collection only. 6. An assignment of a right to payment under a contract to an assignee that is also obligated to perform under the contract. 7. An assignment of a single account, payment intangible, or promissory note to an assignee in full or partial satisfaction of a pre-existing indebtedness. 8. A transfer of an interest in or an assignment of a claim under a policy of insurance, other than an assignment by or to a healthcare provider of a healthcare insurance receivable and any subsequent assignment of the right to payment, but sections 9 to 315 and 9 to 322 apply with respect to proceeds and priorities in proceeds. 9. An assignment of a right represented by a judgment, other than a judgment taken on a right to payment that was collateral. 10. A right of recoupment or set-off, but a. Section 9 to 340 applies with respect to the effectiveness of rights of recoupment or set-off against deposit accounts, and b. Section 9 to 404 applies with respect to defenses or claims of an account debtor. 11. The creation or transfer of an interest in or lien on real property, including a lease or rents thereunder, except to the extent that provision is made for a. Liens on real property in sections 9 to 203 and 9 to 308. b. Fixtures in section 9 to 334. c. Fixture filings in sections 9 to 501, 9 to 502, 9 to 512, 9 to 516, and 9 to 519, and d. Security agreements covering personal and real property in section 9 to 604. Now this changes one's thoughts of what Article 9 really can or cannot do. Let's read on for a better understanding of law in its commercial applications. Also found in the revised Article 9, it reads form of transaction. The form of the transaction or the label that the parties give to the transaction is irrelevant for the purposes of determining whether Article 9 applies. Rather, the determination is based on the economic reality of the transaction. Law, that which must be obeyed and followed by citizens, subject to sanctions or legal consequences, is a law. Citizens exist in the economic reality of corporate America. In Old English jurisprudence, law is used to signify an oath, or the privilege of being sworn. Many U.S. citizens take oaths, even teachers, and there are tons of privileges too. Contract, a promissory agreement between two or more persons that creates, modifies, or destroys a legal relation. An agreement, upon sufficient consideration, to do or not to do a particular thing. According to Bouvier's Law Dictionary, we find this to read, agreement, contract. The consent of two or more persons concurring, respecting the transmission of some property, right, or benefit, with a view of contracting an obligation. BAC. About HT, Commander Dig. HT, Ven. About HT, plowed. 17, 1 Commander Contract 2, 5 Easts are 16. It will be proper to consider, 1, the requisites of an agreement, 2, the kinds of agreements, 3, how they are annulled. 2-1. To render an agreement complete 6 things must concur. There must be, 1, a person able to contract, 2, a person able to be contracted with, 3, a thing to be contracted for, 4, a lawful consideration, or quid pro quo, 5, words to express the agreement, no signature again, only intent, 6, the assent of the contracting parties. Plowed. 161, colit. 35, b. An agreement between 2 or more parties, preliminary step in of which is offer by one and acceptance by other, in which minds of parties meet and concur in understanding of terms. According to Black's law, fourth agreement is, a coming or knitting together of minds, in law a concord of understanding and intention between 2 or more parties with respect to the effect upon their relative rights and duties, of certain past or future facts or performances. Consent, a concurrence of wills. Voluntarily yielding the will to the proposition of another. Acquiescence or compliance therewith. Agreement, the act or result of coming into harmony or accord. Accord, in practice. To agree or concur as one judge with another. Agreements are contracts and contracts fall under the UCC. The UCC is the Uniform Commercial Code. The UCC has been around for thousands of years but just recently became the uniform law in all 50 states. As of July 1, 2001 it makes uniform, to draw less confusion on Article 9 provisions only. Not all agreements fall under Article 9. Some actually still fall under the prior Article 9 and then only if Article 9 itself applies. Because secured parties do not have complete control over where issues of perfection may be litigated, a prudent secured party should prepare for the possibility that perfection may be determined by a court sitting in a state that has not enacted revised Article 9, and, thus, will be applying the choice of law rules of former Article 9. If a dispute concerning the perfection arises in a federal, 6, or state court of a particular state, the forum state, both former Article 9 and revised Article 9 require the application of the choice of law rules in the forum state's Article 9 in order to determine the state, the perfection state, whose substantive laws govern perfection of the security interest. 7. It should be noted that the perfection state in many cases will not be the forum state, rather, the version of Article 9 in effect in the forum state will often direct the court to apply the laws of a different state to determine whether perfection exists. The secured party should consider the possibility that more than one jurisdiction might be the forum state and that there may be several perfection states. The secured party should then consider whether to comply with any of the perfection rules of former Article 9 and, in the case of collateral under revised Article 9 that is not within the scope of former Article 9, whether to comply with any determinable perfection rules under other applicable law apart from former Article 9. A secured party should consider complying with the substantive perfection rules of I. Revised Article 9, 2. Former Article 9, and 3. Other law to the extent any of the following applies. Tangible collateral, such as ordinary goods and instruments, is or might in the future be located in a state other than the state in which the debtor is located under revised Article 9. The debtor's location, as determined under either former Article 9 or revised Article 9, is or might in the future be in a state other than the state in which the debtor is located under revised Article 9. The collateral consists or will consist of assets, such as deposit accounts, that are outside the scope of former Article 9, and the perfection of a security interest in those assets, may require action in a state in which former Article 9 is still in effect. Now for a complete understanding of default. Page 4 of the ABA book entitled The Default Provisions of Revised Article 9 reads, the secured creditor cannot exercise its rights under Part 6, Default Provisions, until after default. The first-time visitor to Article may 9 be surprised to discover that, like its predecessor, old Article 9, Part 6 does not define default. Nor does any other provision of Article 9 or 1-201, the General Definitions section of the UCC, define this all-important term. Instead, the definition, which may be as long as the creditor's arm and as broad as the counsel's imagination, is left to the agreement of the parties. 27 CFR 72.11, Code of Federal Regulations. Meaning of terms, as used in this part, unless the context otherwise requires, terms shall have the meanings ascribed in this section. Words in the plural form shall include the singular, and vice versa, and words importing the masculine gender shall include the feminine. The terms includes and including do not exclude things not enumerated which are in the same general class. Commercial crimes, any of the following types of crimes, federal or state offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling and confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crime. All crime is commercial. More on consent. Michigan legal guidelines. 2. Detention and arrest. A. Levels of encounters. When reviewing the legality of police interactions with citizens, courts initially assess the nature and extent of the contact. To aid in this analysis, interactions, or encounters, are divided into 3 conceptual categories. First, there are encounters of a consensual nature. This has sometimes been called the common law right to inquire. This is a right to ask a question, enjoyed by all citizens, whether they work in law enforcement or not. Occupying the next tier of encounters are interactions of a more intrusive character. These are encounters commonly called detentions, investigatory stops or Terry stops. The justifications offered by law enforcement for this more forceful contact must be based on facts that are specific and articulable, and lead to a rational inference or a reasonable suspicion that criminal activity is being undertaken. The final level of encounter is a formal arrest. To justify this action, law enforcement officials must possess a higher degree of suspicion, i.e., probable cause to believe that a crime is being, or has been, perpetrated and that a specific person committed it. B. Consensual encounters, right of inquiry. The basic premise underlying a consensual encounter is that it is voluntary. Such an encounter is an interaction based on consent and is terminable by either party. Law enforcement officers do not infringe on a citizen's Fourth Amendment rights by merely approaching him or her at random in a public place in order to ask a few questions, as long as a reasonable person would understand that he or she could refuse to cooperate and excuse themselves from the exchange, if they choose to do so. A bit about the UCC 1-207 or 1-308 section. A brief test of this section in practice. 1-308, formally 1-207. Performance or acceptance under reservation of rights. 1. A party who with explicit reservation of rights performs or promises performance or assents to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved. Such words as without prejudice, under protest or the like are sufficient. 2. Subsection 1, does not apply to an accord and satisfaction. According to Black's Law Dictionary, accord means, accord, in practice. An agreement to accept, see accord and satisfaction. The same Black's Law Dictionary for accord and satisfaction means, an agreement between two persons, one of whom has a right of action against the other, that the latter should do or give, and the former accept, something in satisfaction of the right of action different from, and usually less than, what might be legally enforced. Now UCC 1-308, or 1-207, in section 1, makes one believe they have their rights reserved. However, after reading 2, and the definitions of accord and satisfaction, it is easy to see that you are still a party. Even though you are reserving your rights as a party under commercial law, are you not reserving all your rights but only the rights that come from the very agreement you admitted you are a party to? In reality, let's take a look at a hypothetical contract and see what this means. A man goes to a bank and gets a loan. The bank told this man that he would be borrowing the bank's money for this loan. The man later finds out that the bank in fact did not loan their own capital stock and that it is a violation for a bank to use their own capital stock to make a loan. This man wishes to end business, payment, with the bank, yet he signed all his documents with UCC 1-308, or 1-207. He also puts this UCC 1-308, or 1-207, on all communication to the bank explaining his position. A very important question at this time is, how can he, in this hypothetical scene, keep asserting he is a party to the agreement but wants all his rights reserved? Remember, the agreement is the law in commercial law. He is saying that he is a party to a void and deceptive contract. If a contract is bad and void and unfair, deceptive, or false, then why would one even attempt to admit to being a party to it? Just thoughts to ponder as you go through this. The District of Columbia has adopted the UCC. It is irrelevant if the feds have adopted it or not, as they have no venue in which to use it. The several states acquiesced via the Buck Act to become states within states, UCC 1 to 105, and support the feds in their bankruptcy. If the government is operating under the Constitution, then it is operating under Article 1, Section 10, concerning the non-interference with obligations of contract and thusly outside any constitutional restraints or reservations. Title 26 being private law, i.e. colorable, falls here. Government at every level, collectively, has minimal contacts with the people, i.e. driver license, voter registration, fishing license, mobile home registration, trailer and vehicle registration, and so on, ad nauseam. These are all agreements under the UCC. A contract is completed when there is a meeting of the minds and not necessarily when products, papers, funds, or services are exchanged, etc. There are court cases. All governmental functions are now private, not public functions. To prove this statement, read the following case quote as relevant to any discussion of governmental authority regarding the money issue. All courts in every state of the Union, and federal as well, operate under the Clearfield Doctrine from the case of Clearfield Trust Co. v. U.S. 318. U.S. 363, 1943. This case explains the Clearfield Doctrine as this: governments descend to the level of a mere private corporation and takes on the character of a mere private citizen where private corporate commercial paper Federal Reserve notes are concerned. For purposes of suit, such corporations and individuals are regarded as an entity entirely separate from government. Bank of U.S. v. Planters Bank, 9 Wheaton, 22 U.S., 904, 6L. ed. 24 added. The definition of money becomes extremely relevant once the above is known and understood. So, the question is now, what is the substance of the money used by the government entity coming against you? Money as defined in the Constitution for the several states united at Article I, Section 10, Clause 1, or money as defined in the Uniform Commercial Code, UCC, adopted by your state legislature. We have had cases dismissed because the prosecutor would not let us question the officer as to what medium of exchange do you get paid in. The UCC itself states that its definitions are controlling over dictionary definitions. See those UCC definitions as the words are used in the following instances: creditor, debtor, remedy, defendant, document to title, representative, security interest, and loads more in the same section you cited for the definition of money in your article. You must understand that we are all presumed to be the debtor in all interactions with the now private government creditor, dealing in the bankrupt debt/credit system now prevalent throughout the country. When any state agency comes against you, normally no constitutional arguments can be allowed, since it is presumed that you are dealing, knowingly, voluntarily and willfully, in the commercial law of contracts, implied or written. In that state of the forum, you lose all protections of both state and federal constitutions. In your encounter with the term state, be advised that it does not mean the geographical area that you live in. The term state has at least seven meanings in most dictionaries. See UCC 1 to 105, 1, on separate states or nations. In Black's Law Dictionary, under the definition of forum contractus is states, forum contractus. The forum of the contract, the court of the place where a contract is made, the place where a contract is made, considered as a place of jurisdiction. You will note it reads the court where a contract is made. We all are guilty of contracting into the jurisdiction and venue of the courts by our answering yes when asked if we understand the charges. See Black's definition of understand and you will find it to mean agreement. Further, see Black's on lex contractus. In conflicts, the law of the place where the contract was formed, though the term today has undergone changes from the time that substantive questions of law were decided by the law of the place of the making, while procedural questions were decided by the law of the forum. Also see Black's on lex fori. The law of the forum, or court, that is, the positive law of the state, country, or jurisdiction of whose judicial system the court where the suit is brought or remedy sought is an integral part. Substantive rights are determined by the law of the place where the action arose, lex loci, while the procedural rights are governed by the law of the place of the forum, lex fori. Mitchell v. Mitchell, L.A. App. 5 Sir, 483 So.2 D 1152, 1154. Emphasis added. See Black's on public revenue, public money, and you will find it to state that those funds collected go into the government's treasury. Since we know that all the revenue now collected goes to the Federal Reserve, a non-government private bank, the IMF, and the World Bank, and not to the government's treasury, we can safely state they are not collecting public revenue or dealing in public money. Correct. See Grace Commission report during former President Reagan's administration. If it is not public revenue, it must be private revenue. Correct. Under this private system, the only claim by a creditor against a debtor is via the financing statement or the meeting of the minds, understanding, i.e. agreement. Ask for their name to see who you are dealing with. Ask for their claim in the form of a financing statement, contract, agreement, evidentiary instrument, etc. bearing your bona fide signature, wherein you have agreed to the relationship of creditor and debtor. No evidence of a contract, there can be no debt, let alone a debtor. The UCC itself states no person is liable on an instrument unless his signature appears thereon, UCC 3-401, 1. It then goes on to tell how his signature is made. 2. A. UCC definitions: person, party, is presumed to have the requisite contract. When you demand they produce it and they fail, that is material evidence of the non-existence of the agreement. If they can't produce it, it is a false claim and they are bearing false witness and shall suffer punishment therefore. UCC 1-201 definitions section says at 12, creditor, includes, an executor or administrator of an insolvent debtor or assignee's estate. Question: are all administrators in government working as such for an insolvent debtor, i.e. the federal bankrupt government? If your answer is yes, see next. It is well settled in administrative law that, it is the accepted rule, not only in state courts, but, of the federal courts as well, that when a judge is enforcing administrative law they are described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for an agency. 30 calories 596, 167 calories 762. A judge ceases to sit as a judicial officer because the governing principles of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgments for that of the agency. AISIVUS 568 F2D 284. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency. K.C. Davis, Admin Law, CH1, CTP. West's 1965 ed. Their supposed court becoming thus a court of limited jurisdiction as a mere extension of the involved agency for mere superior reviewing purposes. K.C. Davis, Admin Law, P95, CTP, 6 ed. West 1977, FRCVGE 28 IUS 464, Keller VPE, 261 US 428. Thus, the federal government is bankrupt, UCC definition, HJR 192, the state governments have agreed to assist, administration, in the bankruptcy, they are both using private commercial paper as money, they have become private corporations or individuals, by doing so, they are therefore, an entity entirely separate from government. The UCC is the codification of the international law of contracts. On the subject, there is no fraud involved as it all involves obligations of contract. Even God enforces bad contracts. A party is not a party to the action until his signature on an instrument is produced. A party may waive rights, UCC equals remedy, by failure to claim them timely. U.S. v. Johnson, we are all participants in the largest scam, Black's definition, ever devised by man. Thus, the Constitution for the several states united is irrelevant to the lawfulness of the UCC. Contracts, an overview. Contracts are promises that the law will enforce. The law provides remedies if a promise is breached or recognizes the performance of a promise as a duty. Contracts arise when a duty does or may come into existence, because of a promise made by one of the parties. To be legally binding as a contract, a promise must be exchanged for adequate consideration. Adequate consideration is a benefit or detriment which a party receives which reasonably and fairly induces them to make the promise/contract. For example, promises that are purely gifts are not considered enforceable because the personal satisfaction the grantor of the promise may receive from the act of giving is normally not considered adequate consideration. Certain promises that are not considered contracts may, in limited circumstances, be enforced if one party has relied to his detriment on the assurances of the other party. Contracts are mainly governed by state statutory and common, judge-made, law and private law. Private law principally includes the terms of the agreement between the parties who are exchanging promises. This private law may override many of the rules otherwise established by state law. Statutory law may require some contracts be put in writing and executed with particular formalities. Otherwise, the parties may enter into a binding agreement without signing a formal written document. See 110 of the Restatement. Most of the principles of the Common Law of Contracts are outlined in the Restatement Second of the Law of Contracts published by the American Law Institute. See Restatement Second of Contracts. The Uniform Commercial Code, whose original articles have been adopted in nearly every state, represents a body of statutory law that governs important categories of contracts. The main articles that deal with the law of contracts are Article 1, General Provisions, and Article 2, Sales. Sections of Article 9, Secured Transactions, governs contracts assigning the rights to payment in security interest agreements. Contracts related to particular activities or business sectors may be highly regulated by state and/or federal law. See law relating to other topics dealing with particular activities or business sectors. Secured Transaction Law, an overview. A security interest arises when in exchange for a loan a borrower agrees, in a security agreement, that the lender, the secured party, may take specified collateral owned by the borrower if he or she should default on the loan. A security interest also provides the secured party with the assurance that if the debtor should go bankrupt he or she may be able to recover the value of the loan by taking possession of the specified collateral instead of receiving only a portion of the borrower's property after it is divided among all creditors. See bankruptcy. Security agreements are contracts. Article 9 of the Uniform Commercial Code governs security interests in personal property. It has been adopted, with some modifications, by every state. A security agreement must comply with other state laws governing contracts. See Contracts. Article 9 of the Uniform Commercial Code covers most types of security agreements for personal property that are both consensual and commercial. See 9-102, 2, and 9-104 of the Code. This includes fixtures, personal property that is fixed to real property such as a water heater. Statutory liens, e.g. a mechanic's lien, are generally not governed by Article 9 but by the individual statute that creates them. See 9-102, 2, and 9-310 of the Code. Article 9 contains a statute of frauds which requires a security agreement to be in writing unless it is pledged. See 9-203, 1, of the Code. A pledged security agreement arises when the borrower transfers the collateral to the lender in exchange for a loan, example upon broker. The perfection of a security agreement allows a secured party to gain priority to the collateral over any third party. To perfect a security agreement, the filing of a public notice is usually required. See 9-302, 9305 of the Code. Sales Law, an overview. Transactions for the sale and leasing of goods is governed mainly by sales laws of each state. Every state, with the exception of Louisiana, has adopted Article 2 of the Uniform Commercial Code, UCC, as the main body of law regulating transactions in goods. Goods are defined as all things movable and identified to the contract of the sale. See 2-105 of the UCC. It does not include secured transactions, leases, money exchanged as the price, or real property, land and property permanently attached to a piece of land. See secured transactions. To be identified to the contract, a good must be existing and one of the objects that is or will be exchanged. See 2-106, 1, and 2-501, 1, of the UCC. Transactions between merchants and consumers and those solely between merchants are regulated by Part 2. All transactions that are for more than $500 must be in writing. See 2-201, 1, of the UCC. Article 2 regulates every phase of a transaction for the sale of goods and provides remedies for problems that may arise. It provides for implied warranties of merchantability and fitness. See 2-314, 2-315 of the UCC. There is also a duty of good faith in the UCC that is applicable to all the sections. See 1-203 of the UCC. If a contract contains unconscionable provisions, a court may discard the contract or the provisions. See 2-203 of the UCC. Negotiable Instruments Law, an overview. Negotiable instruments are mainly governed by state statutory law. Every state has adopted Article 3 of the Uniform Commercial Code, UCC, with some modifications, as the law governing negotiable instruments. The UCC defines a negotiable instrument as an unconditioned writing that promises or orders the payment of a fixed amount of money. Drafts and notes are the two categories of instruments. A draft is an instrument that orders a payment to be made. An example is a check. A note is an instrument that promises that a payment will be made. Certificates of deposit, CDs, are notes. Drafts and notes are commonly used in business transactions to finance the movement of goods and to secure and distribute loans. To be considered negotiable, an instrument must meet the requirements stated in Article 3. Negotiable instruments do not include money, payment orders governed by Article 4A, fund transfers, or to securities governed by Article 8, investment securities. Checks are negotiable instruments but are mainly covered by Article 4 of the UCC. See also banking law. Secured transactions may contain negotiable instruments but are predominantly covered by Article 9 of the UCC. See also secured transactions. If there is a conflict between the articles of the UCC, both Article 4 and 9 govern over Article 3. Tort law, an overview. Torts are civil wrongs recognized by law as grounds for a lawsuit. These wrongs result in an injury or harm constituting the basis for a claim by the injured party. While some torts are also crimes punishable with imprisonment, the primary aim of tort law is to provide relief for the damages incurred and deter others from committing the same harms. The injured person may sue for an injunction to prevent the continuation of the tortious conduct or for monetary damages. See damages. Among the types of damages the injured party may recover are loss of earnings capacity, pain and suffering, and reasonable medical expenses. They include both present and future expected losses. There are numerous specific torts including trespass, assault, battery, negligence, products liability, and intentional infliction of emotional distress. Torts fall into three general categories: intentional torts, example intentionally hitting a person; negligent torts, causing an accident by failing to obey traffic rules; and strict liability torts, example liability for making and selling defective products. See products liability. Intentional torts are those wrongs which the defendant knew or should have known would occur through their actions or inactions. Negligent torts occur when the defendant's actions were unreasonably unsafe. Strict liability wrongs do not depend on the degree of carefulness by the defendant, but are established when a particular action causes damage. Tort law is state law created through judges, common law, and by legislatures, statutory law. Many judges and states utilize the Restatement of Torts, Second, as an influential guide. The Restatement is a publication prepared by the American Law Institute whose aim is to present an orderly statement of the general law of the United States. For choice of law, jurisdiction. When first diving into this extremely important topic, one must have a clear understanding of the choice parties have for the choice of law option based upon the agreement. Inside the new Article 9 on page 56 it reads, both current and revised Article 9 provide that the secured party is generally liable to the debtor for any loss caused by the secured party's failure to comply with the enforcement provisions of Article 9-507, 1, revised 9-625, b. But case law under current Article 9 in non-uniforms in applying 9-507, 1, to determine what sanctions may be imposed on the non-complying secured party. Revised Article 9 provides that the value of the collateral is presumed to have equaled the entire secured debt, eliminating the deficiency claim, unless the secured party is able to rebut this presumption. Rev 9-626, a. 3. Under both current and revised Article 9, a statutory penalty may be imposed on a non-complying secured party, without damages being proven, where the collateral is consumer goods. 9-507, 1, Rev 9-625, c. 2. Jurisprudence, an overview. The word jurisprudence derives from the Latin term jurisprudentia, which means the study, knowledge, or science of law. In the United States, jurisprudence commonly means the philosophy of law. Legal philosophy has many aspects, but four of them are the most common. The first and the most prevalent form of jurisprudence seeks to analyze, explain, classify, and criticize entire bodies of law. Law school textbooks and legal encyclopedias represent this type of scholarship. The second type of jurisprudence compares and contrasts law with other fields of knowledge such as literature, economics, religion, and the social sciences. The third type of jurisprudence seeks to reveal the historical, moral, and cultural basis of a particular legal concept. The fourth body of jurisprudence focuses on finding the answer to such abstract questions as what is law. How do judges, properly, decide cases? Apart from different types of jurisprudence, different schools of jurisprudence exist. Formalism, or conceptualism, treats law like math or science. Formalists believe that a judge identifies the relevant legal principles, applies them to the facts of a case, and logically deduces a rule that will govern the outcome of the dispute. In contrast, proponents of legal realism believe that most cases before courts present hard questions that judges must resolve by balancing the interests of the parties and ultimately drawing an arbitrary line on one side of the dispute. This line, realists maintain, is drawn according to the political, economic, and psychological inclinations of the judge. Some legal realists even believe that a judge is able to shape the outcome of the case based on personal biases. Apart from the realist-formalist dichotomy, there is the classic debate over the appropriate sources of law between positivist and natural law schools of thought. Positivists argue that there is no connection between law and morality and the only sources of law are rules that have been expressly enacted by a governmental entity or court of law. Naturalists, or proponents of natural law, insist that the rules enacted by government are not the only sources of law. They argue that moral philosophy, religion, human reason, and individual conscience are also integrate parts of the law. There are no bright lines between different schools of jurisprudence. The legal philosophy of a particular legal scholar may consist of a combination of strains from many schools of legal thought. Some scholars think that it is more appropriate to think about jurisprudence as a continuum. Now that you understand what law contracts and jurisprudence are, let's take a closer look at the choice of law sections of the UCC. One of the most important sections of the ABA book revised Article 9 is on page 47. It reads: choice of law. To determine a security interest has attached, has been perfected, or has priority over another interest, it is necessary to ask what law applies. If a dispute occurs in a particular forum in a UCC jurisdiction, the first step is to look to the choice of law rules from Article 9 of the forum jurisdiction to determine which jurisdiction's laws the forum jurisdiction is required to apply. The choice of law rules in the UCC do not address what law a non-UCC jurisdiction would apply. Contract choice of law. The governing law specified in the security agreement will usually be respected by the forum jurisdiction for determining the contractual rights and obligations of the debtor and the secured party, as long as the transaction bears a reasonable relation to the jurisdiction chosen. 1-105, 1. The secured party and the debtor may not by their contract vary the mandatory choice of law rules in current or revised Article 9 dealing with the perfection and priority of a security interest. 1-105. Territorial application of the Act, parties' power to choose applicable law. 1. Except as provided hereafter in this section, when a transaction bears a reasonable relation to the state and also to another state or nation, the parties may agree that the law either of the state or of such other state or nation shall govern their rights and duties. Failing such agreement, this Act applies to transactions bearing an appropriate relation to the state. 2. Where one of the following provisions of this Act specifies the applicable law, that provision governs and a contrary agreement is effective only to the extent permitted by the law, including the conflict of laws rules, so specified. Rights of creditors against sold goods. Section 2-402. Applicability of the article on leases. Sections 2A105 and 2A106. Applicability of the article on bank deposits and collections. Section 4-102. Governing law in the article on funds transfers. Section 4A507. Letters of credit. Section 5-116. Bulk sales subject to the article on bulk sales. Section 6-103. Applicability of the article on investment securities. Section 8-110. Law governing perfection, the effect of perfection or non-perfection, and the priority of security. Interests and agricultural liens. Sections 9-301 through 9-307. 2-402. Rights of sellers' creditors against sold goods. 1. Except as provided in subsections 2 and 3. Rights of unsecured creditors of the seller with respect to goods which have been identified to a contract for sale are subject to the buyer's rights to recover the goods under this article. Sections 2-502 and 2-716. 2. A creditor of the seller may treat a sale or an identification of goods to a contract for sale as void if as against him a retention of possession by the seller is fraudulent under any rule of law of the state where the goods are situated, except that retention of possession in good faith and current course of trade by a merchant seller for a commercially reasonable time after a sale or identification is not fraudulent. 3. Nothing in this article shall be deemed to impair the rights of creditors of the seller. A. Under the provisions of the article on secured transactions, Article 9, or B. Where identification to the contract or delivery is made not in current course of trade but in satisfaction of or as security for a pre-existing claim for money, security, or the like, and is made under circumstances which under any rule of law of the state where the goods are situated would apart from this article constitute the transaction of fraudulent transfer or voidable preference. 3 to 102. Subject matter. A. This article applies to negotiable instruments. It does not apply to money, to payment orders governed by Article 4A, or to securities governed by Article 8. B. If there is conflict between this article and Article 4 or 9, Articles 4 and 9 govern. C. Regulations of the Board of Governors of the Federal Reserve System and operating circulars of the Federal Reserve Bank supersede any inconsistent provision of this article to the extent of the inconsistency. 4 to 102. Applicability. A. To the extent that items within this article are also within Articles 3 and 8, they are subject to those articles. If there is conflict, this article governs Article 3, but Article 8 governs this article. B. The liability of a bank for action or non-action with respect to an item handled by it for purposes of presentment, payment, or collection is governed by the law of the place where the bank is located. In the case of action or non-action by or at a branch or separate office of a bank, its liability is governed by the law of the place where the branch or separate office is located. 4A 507. Choice of law. A. The following rules apply unless the affected parties otherwise agree, or subsection C applies. 1. The rights and obligations between the sender of a payment order and the receiving bank are governed by the law of the jurisdiction in which the receiving bank is located. 2. The rights and obligations between the beneficiary's bank and the beneficiary are governed by the law of the jurisdiction in which the beneficiary's bank is located. 3. The issue of when payment is made pursuant to a funds transfer by the originator to the beneficiary is governed by the law of the jurisdiction in which the beneficiary's bank is located. B. If the parties described in each paragraph of subsection A have made an agreement selecting the law of a particular jurisdiction to govern rights and obligations between each other, the law of that jurisdiction governs those rights and obligations, whether or not the payment order or the funds transfer bears a reasonable relation to that jurisdiction. C. A funds transfer system rule may select the law of a particular jurisdiction to govern I. Rights and obligations between participating banks with respect to payment orders transmitted or processed through the system, or 2. The rights and obligations of some or all parties to a funds transfer, any part of which is carried out by means of the system. A choice of law made pursuant to clause I is binding on participating banks. A choice of law made pursuant to clause 2 is binding on the originator, other sender, or a receiving bank having notice that the funds transfer system might be used in the funds transfer, and of the choice of law by the system when the originator, other sender, or receiving bank issued or accepted a payment order. The beneficiary of a funds transfer is bound by the choice of law if, when the funds transfer is initiated, the beneficiary has noticed that the funds transfer system might be used in the funds transfer, and of the choice of law by the system. The law of a jurisdiction selected pursuant to the subsection may govern, whether or not that law bears a reasonable relation to the matter in issue. D. In the event of inconsistency between an agreement under subsection B and a choice of law rule under subsection C, the agreement under subsection B prevails. E. If a funds transfer is made by use of more than one funds transfer system and there is inconsistency between choice of law rules of the systems, the matter in issue is governed by the law of the selected jurisdiction that has the most significant relationship to the matter in issue. 5 to 116. Choice of law and forum. A. The liability of an issuer, nominated person, or advisor for action or omission is governed by the law of the jurisdiction chosen by an agreement in the form of a record signed or otherwise authenticated by the affected parties in the manner provided in section 5 to 104, or by a provision in the person's letter of credit, confirmation, or other undertaking. The jurisdiction whose law is chosen need not bear any relation to the transaction. B. Unless subsection A applies, the liability of an issuer, nominated person, or advisor for action or omission is governed by the law of the jurisdiction in which the person is located. The person is considered to be located at the address indicated in the person's undertaking. If more than one address is indicated, the person is considered to be located at the address from which the person's undertaking was issued. For the purpose of jurisdiction, choice of law, and recognition of interbranch letters of credit, but not enforcement of a judgment, All branches of a bank are considered separate juridical entities, and a bank is considered to be located at the place where its relevant branch is considered to be located under the subsection. C. Except as otherwise provided in the subsection, the liability of an issuer, nominated person, or advisor is governed by any rules of custom or practice, such as the uniform customs and practice for documentary credits, to which the letter of credit, confirmation, or other undertaking is expressly made subject. If I. This article would govern the liability of an issuer, nominated person, or advisor under subsection A, or B. 2. The relevant undertaking incorporates rules of custom or practice, and 3. There is conflict between this article and those rules as applied to that undertaking. Those rules govern except to the extent of any conflict with the non-variable provisions specified in section 5-103, c. D. If there is conflict between this article and Article 3, 4, 4a, or 9, this article governs. E. The forum for settling disputes arising out of an undertaking within this article may be chosen in the manner and with the binding effect that governing law may be chosen in accordance with subsection A. 5-103. Scope. A. This article applies to letters of credit and to certain rights and obligations arising out of transactions involving letters of credit. B. The statement of a rule in this article does not by itself require, imply, or negate application of the same or a different rule to a situation not provided for, or to a person not specified, in this article. C. With the exception of the subsections, A, and D, sections 5-102, A, 9, and 10, 5-106, D, and 5-114, D, and except to the extent prohibited in sections 1-302 and 5-117, d. The effect of this article may be varied by agreement or by a provision stated or incorporated by reference in an undertaking. A term in an agreement or undertaking generally excusing liability or generally limiting remedies for failure to perform obligations is not sufficient to vary obligations prescribed by this article. D. Rights and obligations of an issuer to a beneficiary or a nominated person under a letter of credit are independent of the existence, performance, or non-performance of a contract or arrangement out of which the letter of credit arises or which underlies it, including contracts or arrangements between the issuer and the applicant and between the applicant and the beneficiary. 6-103. Applicability of Article 1. Except as otherwise provided in subsection 3, this article applies to a bulk sale if A. The seller's principal business is the sale of inventory from stock, and B. On the date of the bulk sale agreement the seller is located in the state, or, if the seller is located in a jurisdiction that is not a part of the United States, the seller's major executive office in the United States is in the state. 2. A seller is deemed to be located at his or her place of business. If a seller has more than one place of business, the seller is deemed located at his or her chief executive office. 3. This article does not apply to A. A transfer made to secure payment or performance of an obligation. B. A transfer of collateral to a secured party pursuant to Section 9-609. C. A sale of collateral pursuant to Section 9-610. D. Retention of collateral pursuant to Section 9-620. E. A sale of an asset encumbered by a security interest or lien if I. All the proceeds of the sale are applied in partial or total satisfaction of the debt secured by the security interest or lien, or 2. The security interest or lien is enforceable against the asset after it has been sold to the buyer and the net contract price is 0. 8-110. Applicability, choice of law. A. The local law of the issuer's jurisdiction, as specified in subsection D, governs 1. The validity of a security. 2. The rights and duties of the issuer with respect to registration of transfer. 3. The effectiveness of registration of transfer by the issuer. 4. Whether the issuer owes any duties to an adverse claimant to a security, and 5. Whether an adverse claim can be asserted against a person to whom transfer of a certificate or uncertificated security is registered, or a person who obtains control of an uncertificated security. B. The local law of the securities intermediary's jurisdiction, as specified in subsection E, governs 1. Acquisition of a security entitlement from the securities intermediary. 2. The rights and duties of the securities intermediary and entitlement holder arising out of a security entitlement. 3. Whether the securities intermediary owes any duties to an adverse claimant to a security entitlement, and 4. whether an adverse claim can be asserted against a person who acquires a security entitlement from the securities intermediary or a person who purchases a security entitlement or interest therein from an entitlement holder. C. The local law of the jurisdiction in which a security certificate is located at the time of delivery governs whether an adverse claim can be asserted against a person to whom the security certificate is delivered. D. Issuer's jurisdiction means the jurisdiction under which the issuer of the security is organized or, if permitted by the law of that jurisdiction, the law of another jurisdiction specified by the issuer. An issuer organized under the law of the state may specify the law of another jurisdiction as the law governing the matters specified in subsection A. 2 through 5. V. Rules on perfection, attachment, and priority. The most important elements that must be known and understood under the UCC are 1. Perfection, filing. Not always mandatory. 2. Attachment, most powerful of all. No attachment, no perfection, or control. 3. Possession, in possession of document. 4. Control, not in possession but in control. Someone holds for you. 5. Priority, whoever attaches first has priority. Priority grants enforcement. Enforcement to the collateral cannot be accomplished until the above are met. Perfection. The fundamental policy underlying perfection is to permit discovery of security interests without complete reliance upon making an inquiry through the debtor. Source: ABCs of the UCC Revised Article 9, 9-310. Filing. 9-310. When filing required to perfect security interest or agricultural lien, security interests and agricultural liens to which filing provisions do not apply. A. General rule: perfection by filing. Except as otherwise provided in subsection B and section 9-312 B, a financing statement must be filed to perfect all security interests and agricultural liens. B. Exceptions: filing not necessary. The filing of a financing statement is not necessary to perfect a security interest. 1. That is perfected under section 9-308 D, E, F, or G. 2. That is perfected under section 9-309 when it attaches. 3. In property subject to a statute, regulation, or treaty described in section 9-311 A. 4. In goods in possession of a bailee which is perfected under section 9-312 D, 1, or 2. 5. In certificate securities, documents, goods, or instruments which is perfected without filing or possession under section 9-312 E, F, or G. 6. In collateral in the secured party's possession under section 9-313. 7. In a certificate security which is perfected by delivery of the security certificate to the secured party under section 9-313. 8. In deposit accounts, electronic chattel paper, investment property, or letter of credit rights which is perfected by control under section 9-314. 9. In proceeds which is perfected under section 9-315, or 10, that is perfected under section 9-316. C. Assignment of perfected security interest. If a secured party assigns a perfected security interest or agricultural lien, a filing under this article is not required to continue the perfected status of the security interest against creditors of and transferees from the original debtor. 9-308. When security interest or agricultural lien is perfected, continuity of perfection. A. Perfection of security interest. Except as otherwise provided in this section and section 9-309, a security interest is perfected if it has attached and all of the applicable requirements for perfection in sections 9-310 through 9316 have been satisfied. A security interest is perfected when it attaches if the applicable requirements are satisfied before the security interest attaches. B. Perfection of agricultural lien. An agricultural lien is perfected if it has become effective and all of the applicable requirements for perfection in section 9-310 have been satisfied. An agricultural lien is perfected when it becomes effective if the applicable requirements are satisfied before the agricultural lien becomes effective. C. Continuous perfection, perfection by different methods. A security interest or agricultural lien is perfected continuously if it is originally perfected by one method under this article and is later perfected by another method under this article, without an intermediate period when it was unperfect. D. Supporting obligation. Perfection of a security interest in collateral also perfects a security interest in a supporting obligation for the collateral. E. Lien securing right to payment. Perfection of a security interest in a right to payment or performance also perfects a security interest in a security interest, mortgage, or other lien on personal or real property securing the right. F. Security entitlement carried in securities account. Perfection of a security interest in a securities account also perfects a security interest in the security entitlements carried in the securities account. G. Commodity contract carried in commodity account. Perfection of a security interest in a commodity account also perfects a security interest in the commodity contracts carried in the commodity account. Attachment. Attachment does not mean attachment by contract to an individual like most may believe or try to find. They will not find it anywhere. The reason is simple. The UCC only allows for an interest to be created in a property right based upon an agreement. Attachment requires three things, and without these three things no attachment, perfection, possession, let alone priority or